My lords, my lady.
Yes, Mr. White.
Dealing then with the issue around the evidence of Mr. Cook, if I could take you to divider 5 in bundle B, please, and B71, and I start at line 17 with my learned friend Mr. Porter asking the question. My lords will debate in due course how valuable your lordship may find that, but I can just ask you this. From what you know and what you say then about Mr. Cook, if he'd seen a hole of the sort we've seen in this photograph, he'd raise a category 1. That's what you'd expect him to do. I'd expect him to work as per the DMA. A slight avoidance of the question. I'd expect him to raise a category 2 medium defect.
Forgive me, is this Mr. Alan Smith?
No, it's Mr. Vine, my lord.
Mr. Vine, right.
Sorry, I should have said that. B72, as per DMA, seriously, yes, as per DMA. If I can turn to page B73, at line 10, my learned friend establishes with Mr. Vine that he'd worked as a highways inspector and then asks him to give his own view. And if we go over the page to B74, lines 19 to 25, he says it's category 2. Page B75, top line, category 2 medium, as per the DMA. The next page at B76 is Mr. Alan Smith's evidence. And if we could please go to page B90. At the top of the page, my learned friend says this: Your Lordship will appreciate I proceed with caution because this, as it were, is indirect evidence from a witness who's declined to come to court. I think everyone's agreed that he's identified category defect with verge damage at various points along the situation. We were looking at this with a different witness. Do you see a priority, my Lord, category 2? Yes. And then he goes through details of the inspection report, and at line 18, if we look at this photograph supplied by the claimant 138 and following it, it's clear, isn't it, from the tenor of your statement, you're confident in Mr. Cook's ability to recognise that as a category 1 defect and not a category defect of that sort he did record. And then there's an exchange, but if we go to B91 line 13 downwards. Well,
yes, this page we were shown yesterday.
Yeah. So he's putting to Mr. Alan Smith, my lord, first of all, that Mr. Cook would have categorised it as a category 1 defect, and secondly, that he himself would have done so, as he did with Mr. Vine. And we see that at page B94 and B95. At line 15, let's break it down into smaller steps. You're telling my lord that the hole we see at page 138 is a category D defect, yes. And then he goes back to Mr. Cook's inspection records. And so, with both Mr. Vine and Mr. Alan Smith, my learned friend is trying to introduce through them what Mr. Cook would have categorised the hole as a category 1.
Yes.
Mr. Alan Smith then stops giving evidence, and we have just a second please. We have at page B126, after re-examination line 9, I ask if he could stay because I want to deal with the highways map as I've identified, A29 in your bundle.
So sorry, Mr. Waxman, I missed the page reference.
I do apologise, my lady. B126.
Thank you.
And then we enter into the debate. And my lord, I say I have no further questions for this witness may be released. Mr. Porter says I do, I am afraid. I say I object. The deputy says, what does your question concern? I'm going to ask the witness, if I may, whether he knows how Mr Cook would have recorded the defect shown in the photographs. I say that doesn't arise, and he says, the deputy says, I'm going to allow the question. If you need to ask questions out of
Right.
I'm going to allow you to.
Don't have to read it out.
My apologies, madam. And then I identify that the questions to be asked need to be asked very carefully. Because there is a distinction between asking about credit and seeking to put into evidence Mr Cook's categorisation.
In the sense of putting it to the witness.
Exactly.
Yes.
If you put to the witness, this is what another witness has said,
Yes.
you are admitting that evidence.
Well, that's the big question which we have to decide. So those are the facts on which it arose.
And if you look at the discussion through to B142, it's clear in my submission that what my learned friend is seeking to do, as my lord has identified, is put the facts in Mr Cook's statement to those witnesses, or to Mr Alan Smith,
Yes.
Mr Fine has got. Now, he is asked if he wants to think overnight. Sorry, he's asked if he wants to frame some questions to discuss with me, so that overnight the judge can consider the position. And he declines that offer. And there is no ruling on this issue. My learned friend Mr Porter decided he would put the statement in under CPR 32.5. That he is seeking to adduce evidence of what Mr Cook would have said about the whole to challenge the witness's account, both as to what they say Mr Cook would have said, but also their own account of what this whole was. And if you are seeking to rely on evidence to challenge someone, you have to put it in evidence,
Well,
put it into evidence.
That is the big question, isn't it?
It is, my lord.
Is that was not the question considered in the property finance case.
I'm so sorry, my lord.
That was not the issue in the property finance case, was it?
Well, it was in part, my lord, because both in that at McPhillamy, what was being discussed was whether you could rely on only parts of a witness statement. So it was accepted that parts of those witness statements in both the property finance and McPhillamy were going to be put into evidence. And the
Yes.
Justice Brooke in McPhillamy and in property finance, the judge ruled that you had to put in the whole statement.
Yes.
You cannot assert a fact arising from a witness statement and cross-examine on someone on that fact without putting that statement into evidence.
Well, that's the proposition.
Yes.
Has that expressly been held in any case?
Overnight, I've looked at some of the criminal jurisprudence, and you could put a document for someone to look at to try and change their opinion.
Yes.
But once you start referring to the contents, you're admitting it into evidence.
Yes. That doesn't, by all means, show us criminal cases if you want to, and I'm sure you're right, but I'm not sure that what happens in the Crown Court is very helpful. But anyway.
I mean, if you think of Lord Denham's rule, you can put an inconsistent statement to someone and they can accept it or not, but you have to put a third-party statement into evidence to cross-examine, otherwise it has no status.
Oh,
But if you'd like to show us any authority, criminal or civil, to back up what you've just said, I think civil would be more useful, but if you'd like to show us any authority, then please do.
My lord, I cannot point to any specific authority, but it seems to me to follow from the normal rules of evidence.
And that once you do that, whole statement is in tra-la-la-la-la, and even though it's 50%, 80%, 90% adverse to the party who wants to challenge the witness.
Well, my lord, that was
Yes,
exactly...
that is exactly your case.
Yeah, that was exactly the point in McPhillamy and in property. They only wanted to rely on parts of the statement to prove parts of the fact.
Yeah.
So here, my learned friend wanted to establish that this was a category 1. Neither Mr. Vine...
Wanted to establish that Mr. Cook would have categorised it as category 1 if he had seen the whole.
My lord, he also wanted to establish that it was a category 1 for Mr. Allen
Yes,
Smith and Mr.
ideally.
And they didn't deal with this issue at all in their witness statements. It was only raised in cross-examination.
Well, that's not quite right, is it? Because we've seen the witness statement, and one of the witnesses says something about, well, it wouldn't have been necessary to raise a work order, and you trace that back, and that therefore means it's not a category 1 defect. So it isn't right to say they don't deal with the category 1, category 2 point. Like everything else in this case, it's very elliptical, and you have to know the code to get there, but you do get there in the end. So I'm afraid I don't accept that submission, speaking for myself. I think the witnesses did deal with it, and I think Mr. Porter was entitled to raise it with them.
I've no doubt whatsoever that my learned friend was entitled to raise it. Of course he was. It was an important part of his case that this was dangerous, and a category 1 would have established that it was dangerous. And he asked questions of their own view of it, and he asked questions of what Mr. Cook had said about it, and they both gave him answers that he did not like. So
well,
then
they were also answers that were contrary to what was in Mr. Cook's witness statement, which they had read.
Well, I'm not... If he had wanted to challenge credibility, that's one thing, but he wanted to establish the facts of what Mr. Cook had said. So he wanted to say, this is his evidence on this issue. So he was relying
How are you going to
evidentially...
how are you going to challenge the credibility of the witness without saying,
Well,
you've speculated as to what Mr. Cook would have said about this categorisation. Let me show you what he actually did say in terms of categorisation. You're wrong.
Well, you have to put the statement in my assumption, my lady.
So you can't cross-examine on the point on credibility,
You
then?
can show the statement to say that's wrong. Look at that document. Do you want to reconsider your answer? But once you start referring to the contents of the statement to the judge, you are in effect admitting that evidence. And that's precisely...
Sorry, just say that again. You say Mr. Porter could have put to the witness.
You could have shown the witness the statement
Yes.
and said, do you want to reconsider your answer?
Well, I thought that's what he was trying to do.
No, my lord. He wanted to establish the fact of what Mr. Cook had said by introducing that evidence.
So, right. So he could have.
Shown them Mr. Cook's statement.
Well, that was my criminal research over the evening. That in cases you can show someone a document and ask if that changes their mind.
Yes. Yes.
And there is a distinction between that challenge to credibility and putting the evidence in, which is why I said he had to be very careful and why the judge indicated that he'd consider questions.
But you're saying, yes. So he could have put that to Mr. Allen Smith, if Mr. Allen Smith had been And if Mr. Alan Smith said, well, I don't care what's said in this witness statement, I still think Jeff would have categorised this as category 2, then Mr. Porter would not have been allowed to refer to the contents of that statement without
putting it in.
Taking the whole thing.
Yes.
Well, speaking for myself, Mr. Weitzman, that's what the law provides. The law is an ass, I think.
Well, my lord, if you look at the cases which we'll go to in a second.
Right, let's do that.
They acknowledge that in the Air Canada quote, which is at the end of McPhillamy, that it's an adversarial process and that some evidence may be missing and the judge makes their own decision.
But McPhillamy wasn't a case dealing with a situation where the court would be misled if the evidence were left to rest where it was. I mean, we're dealing here with a very different situation. We're dealing with a situation where a witness says something blatantly wrong. On one view, that witness knows it's blatantly wrong. And you're saying that the other side can't correct that except by silently showing him a document that shows it's blatantly wrong. And if he digs his heels in and refuses to accept it, then you're stuck because you've got to put it in warts and all.
You have to, if you're putting in the fact of what someone does, yes, you're putting in part of the statement, so you have to put in all of the statement. And that's precisely, in my submission, what McPhillamy is dealing with. There you have a situation where you only want to rely on part of the statement because the other parts are not helpful. If we look at McPhillamy, it's at 7. Page 116, please, sets out the previous rules, and then if we go over to page 117, it deals with CPR 32.5. In other words, it abrogates the old rule and makes permissive what the old rule prevented. It's then a matter for the discretion of the judge whether to permit it. In my judgment, however, there's nothing in the new rule to change the basic rules of the laws of evidence, which existed before the new rule was introduced by the rule makers and which are still in force today. And then it takes us to the Filitrata legacy. And if we go, please, to page 120 and 121, H on 120, because my learned friend, I think, dealt with F on 120. This is all very familiar territory. The rules of evidence have grown up, as I said, largely in more traditional times when the party called their evidence orally. Mr. Price is relying on the change of the rule, in my judgment, to drive a coach and horses through the principle of the laws of evidence. They've previously been understood. He wishes to put before the jury's hearsay evidence on his client's behalf, the evidence of a man which he says straight away is very substantially extent untrue. When I asked, would he accept that Mr. Abernethy, who is not a party prisoner, should be called to be cross-examined by Mr. Caldecott, he said no. He regarded this as a very uncivil suggestion on the basis that if Mr. Caldecott decided not to call him, he would not be in a better position by being able to have a scope in cross-examination than he would with one of his own witnesses in chief. However, I know of no principle of law of evidence by which a party may put in evidence a written statement of a witness, knowing that his evidence conflicts in a substantial way with the case he's seeking to place before a jury, on the basis he would say straight away in the witness' absence that the jury should disbelieve as untrue a substantial part of that evidence.
But that's dealing with a very different situation. There was no witness being called by the opposing party that was trying to second guess the evidence of the witness. in a way which was known or potentially could have been known to be inaccurate, to use a neutral word. This was the classic example of a case where the party who didn't call the witness to start with, or whose evidence wasn't served, is trying to rely on evidence from the opposing party, but they want to cherry pick. And when you're trying to do that, you can't do it. Well, that's as clear as daylight, it seems to me. But the cherry picking rule is a very different rule from the rule about trying to put in evidence for the purposes of curing a misleading impression.
Well, my lady, if you are putting in part of the statement, as you say, to cure the misleading impression, by definition, you're saying we rely on this evidence from X. So you are admitting it into evidence. We agree on that. Once you have admitted part of a statement, the law doesn't allow you not to rely on the whole of it. There's no dispute that Mr. Porter wanted to put in that part of the statement. The question is whether he could do it in isolation from the rest, which is what was happening in McPhillamy and Property Alliance. And my submission is that once you go down that route, you're bound to include the whole statement, which is what Mr. Porter decided to do, but attributing different levels of weight.
If that's right, then he's thrown away the case. Simple as that. You say he had no case anyway, but if you're right on that point, he's thrown away the case.
Well, my lord, he has included evidence. I don't say he's thrown away the case, no, my lord, because at no point did we say that the judge could make his own decision about Mr. Cook. It's obviously a matter for the judge to weigh the evidence. We say when you impugn your own witness, the judge has to be careful and have cogent reasons. And that's what I submitted to the judge on the day of when we dealt with that area. We never described it in black and white terms. So if I can take you to the transcript again, please. At B. .391. At the top of the page A, finally on Mr. Cook, my learned friend has taken you to the notes in the white book.
Sorry, no, 91 of the bundle or 91?
391. My apologies, mate.
391.
So this is the oral submissions after the written submissions have been exchanged. And we know that Mr. Cook is being impugned by the appellant. And I make the submission at B. It's quite clear that my learned friend is saying that Mr. Cook has lied in his witness statement when he signed with a statement of truth. My position was not that you cannot look at other evidence, because of course you always can. What a party cannot do is call someone and say that part of their statement is lies, because that is doing exactly the same thing as saying you should not, and I think it should say admit it there. I think that's a typographical error. Finally, I did not call him. It's correct my own friend said the evidence was unsatisfactory, which is why he was not called or why we did not put his statement in. So what we invited the judge to do, and I'll take you to the authorities and say it is in accordance with those authorities, is consider Mr. Cook's statement in light of the GPS tracking and come to his own decision that he had to be careful of finding that he had lied, given that it was the appellant who had put his statement in and was seeking to impugn it. And in my submission, that's exactly what the judge did.
Right. Authorities next.
Yes, my lord. Yes. Can we go, well, just finishing with McPhillamy, final paragraph, citing Air Canada. And it's the citation from Lord Wilberforce. He identifies the potentials for imperfection of evidence, and adjudication has to be made, which may not be in the whole truth of the matter.
Sorry, this is...
Sorry, McPhillamy,
Oh,
at page 121, my lord.
go on. Citing Air Canada, yes. Sorry.
I'm just looking at what Lord Wilberforce, the citation from Lord Wilberforce in Air Canada at ENF.
And you rely on that for what?
Well, my lord, I say that that's the approach the judge took here. He looked at the evidence. He considered the GPS tracking. He did not feel that on the basis of the GPS tracking, he could find that Mr. Cook was a liar, which was what he was being asked to find.
He wasn't.
Oh.
He wasn't.
He wasn't.
Well, he
Well,
was.
we checked the transcripts. I did not at any point ask the
Well,
judge to...
let's go to the transcripts and I'll deal with that.
It's true, my learned friend, that in his response to my submissions, that he thought it quite clear that I'm saying he's lied in his witness statement. I'll be corrected if I'm wrong. I said he was unreliable.
If we look at B321 behind divider 7, page B333,
Yes.
he deals at paragraph 39 with the tracking, and then at 40 in the last two lines, he must immediately have lodged the inspection report, strongly implying he did not carry out the claimed inspection at all. Now, if he's claimed to have done an inspection and he doesn't do that, and that's the inference you're asking the judge to make, that's accusing him of telling a lie. Well, my lady, he's filled out a report saying he did this inspection. And my learned friend's case is that he did not do the inspection.
Well, he did not do a
Walked inspection.
No, my lord, with the greatest respect, this is an inspection which is walked. You cannot do it from a car.
Well, it doesn't say that, and it's all part of the shadow boxing in this case. We've got one very small inspection report which repeats word for word a report from 6 months previously.
Well,
It doesn't say walked, it doesn't give any indication as to that.
He says
That's
he-
all we've got.
no,
He says
And
he
we
would
haven't
have
got a
taken...
called witness because Mr Cook didn't give evidence. All this
Mr
stuff
Cook
about
says he would
who
have taken
called
10 minutes and the GPS says he'd stop for 3. I mean,
well, my lady, I accept you question Mr Cook's evidence on the basis of the GPS.
Well, the judge seems to say it's completely worthless.
He considers it, he
Doesn't
considers...
say why.
Well, he does at paragraph... he goes through it in a little detail at the paragraph you were taken to before lunch, at 71, page 96.
Sorry, in the judgment, yes.
he says, well, I'm not going to read it out, but I think you were taken to the first 3 lines. He identifies
we were taken to it all, weren't we? Because this is the one where he says it's of minimal weight, and then there's then at 136 he says I'm unable to place any weight on the GPS evidence.
well,
So 71 plays 136.
Indeed, but what he's doing at 71 is going through the elements of evidence in relation to it. So he is considering what we have said about it in the email that is inaccurate. He's then looking at what was presented to him by the claimant in closing, which is extracts from a US government website and Google Maps concerning accuracy of Google Maps, and finding that that cannot fill the gap, not having been introduced and analysed by a suitable expert. I accept that the location timing data cannot be relied on as accurate, and I therefore place minimal weight on the location timing evidence. So what he's done is he's looked at the document, looked at the appellant's submissions about it, and then said, given my concerns about that, it would be surprising if Mr. Cook had seen fit to be deceptive in such an important way, and there would need to be cogent evidence to prove it, which is lacking.
So he's assuming that the case is Mr. Cook is lying.
He is. Yes.
Nowhere in the judgment does he deal with the alternative that Mr. Cook was simply mistaken. He didn't remember this inspection.
My lord, no, you're absolutely right. He doesn't do that. But in my submission, it is clear that it is being suggested that Mr. Cook did not do the inspection, created a report of the inspection, which he could not have created accurately if he had done it.
So, yes, right. So I've got it. Your case is this. The claimant is accusing Mr. Cook of lying.
Yes.
He's not allowed to do that because of the rule in property alliance.
Yes.
Mr. Cook's statement must be taken as gospel truth.
No.
Or at any rate, true and great weight attached to it, so that any apparently objective data such as A32 GPS tracking, which contradicts it, must be rejected as being of no value, because if unless Mr. Cook was telling lies, the GPS data must somehow be wrong in respects which the judge doesn't specify. That's the
My
case,
lord,
isn't it?
that's not the case, no. What I say is he has to look at all the evidence and carefully balance it.
Yes.
But if he's making a decision in relation to Mr. Cook, who my learned friend has introduced the evidence of, then he has to be careful before he finds that he is lying. So he has to have cogent evidence to do that. Mm-hmm. And the GPS data was not that cogent evidence.
Why not?
Because it's not in any way explained. There are assumptions made about where he was, the timings, and we don't even know, for example, what the yellow dots mean. Do they mean he stopped? I don't know the answer to that. It was simply a document introduced in closing submissions, which we had said we doubted the accuracy of, in relation to timings and locations.
You may have doubted the accuracy. You didn't actually adduce any evidence to suggest that it was inaccurate, and it was a document disclosed by your side under cover of an email from the instructing solicitor that led the other side to believe that it would be dealt with in witness statement when it wasn't. So the fact that it's referred to in closing submissions for the first time, I don't think is really a good point.
Well, my lady, I've made the point. You either accept it or not.
I mean, I'm just looking, I've been reminding myself of the way in which Mr. Porter dealt with it in his written closings, and it's pretty compelling to me, I must say.
Well, my lady, if it's pretty compelling, in my submission it must be correct. In effect, he's saying he's lying. Because he simply cannot have, if he's filled out that form without doing a working inspection, then it's untrue. He's falsified the document.
He may have got out of his car for 3 minutes and done a cursory inspection, but what he hasn't done is a 10-minute walking inspection of the type that he says in his witness.
Well, if it takes him 10 minutes to walk that length of footway, and he's done a cursory inspection for 3 minutes, he hasn't done what he said he's done. So he's lying. And if Mr. Porter had him in the box, he'd have said that to him. If he'd been cross-examining him, that's what he would have put to him. You did not do it. And that's what he was saying the GPS tracking established.
And we may have changed since I did first instance trials, but most judges don't want to find people lying. Most counsel don't want to cross-examine on the basis that people are lying. Most counsel want to cross-examine on the basis that they're mistaken. Given the very feeble part of his witness statement dealing with this inspection, which is all I would have done this, I would have done that, that's certainly the line I would have taken if I'd been Mr. Porter and if I had been the first instance judge. And that you might get to lying, depending on the answers, but your first go is that he's just not remembered doing the inspection at all. And that's not surprising given the hundreds of inspections he's
you say
probably
you
done.
carried out an inspection and you found various dents in the verge and so on and so forth, but now that you've seen this GPS, it indicates you can't have been out of your car for more than 3 minutes, so you can't have done 10 minutes. Would you agree or disagree? You might well have said, well, yes, I was mistaken. Trouble was, he didn't turn up.
If we look at page B333, paragraph 40, last sentence, he must immediately have logged his inspection report. In this 9-minute period of time, he cannot possibly parked up, done a walk inspection, walked back to his car, driven from the roundabout. Mr. Cook clearly had a lot to answer from cross-examination. It's hardly surprising that he refused to give evidence on oath to support his counter suspecting the path. And then he does rely on that part which he's admitted to category 1.
Well, in order to give that, can I just intervene to say I was assuming wrongly, as it turns
That he'd seen it.
that
That he'd
Mr.
seen
Cook
the GPS.
would have been shown the GPS data.
No. I'm very sorry, this is the closing submission. So this isn't part of the transcript. This is after all the evidence has been called.
Yes, but I think the point that Mr. Porter is very fairly making is that when he's making submissions in relation to Mr. Cook and his unwillingness to come to court, he's labouring under what we now know to be the misapprehension that Mr. Cook would have been shown the GPS data and had deliberately failed to answer questions about it. You're now telling me it was an oversight by your instructing solicitor and that the GPS data was never even put to Mr. Cook. So Mr. Cook is in blissful ignorance of the fact that there is a contemporaneous document which contradicts what he says. He's never had an opportunity to deal with it, but the first time we found out about that is in this court.
Well, my lady, obviously have to accept that I explained that given those.
Yes. And I accept the explanation. Of course I do, Mr. Weitzman.
Well, I'm most grateful.
But
Can I take you to B389, my lady?
you can see, however, why the assumption would have been made until you made that explanation that factors were different. Because normally you would expect that the witness would have seen it.
Well, my lady, if that's right, then it's clear that when the judge was dealing with it, he was right to take the inference that it was being said that Mr. Cook was lying.
All right, well, I think we've done this point today.
Well, can I just
It's a very
take-
important one. If you want to show us any other authority.
I want to go to the filatrage.
I thought you
Yes.
pointed it.
Can I just, for your note, ask that you look at B389 C and D.
Yes.
Can we look, please, at the Filtrata legacy at page 40? First column, end of the first paragraph. The proposition is, it's an absolute rule of law which prohibits the party from asserting that evidence given in chief by a witness whom he has called is untruthful. That accordingly the plaintiff's attempt to do so is ineffectual. And then second column, last paragraph, about 10 lines down, it starts, it may perhaps be the case that there's a distinction between what is permissible for a party and what is within the powers of the judge. As to the later, we recognise that in principle an adversarial system of civil procedure requires the judge to decide the issues placed before him on the evidence given at trial, so far as such a decision is necessary for a resolution of the dispute. It's not general for the judge to raise issues with the parties themselves who have chosen not to raise. Nevertheless, the object of the procedure is to achieve justice, and we should be slow to hold that the judge were to conclude that the range of the evidence made no sense unless an item of unchallenged evidence wasn't true. He would have no power to satisfy himself with the position, subject of course to every precaution necessary to avoid unfairness to the parties and the witness. So in effect, that is what we were submitting to the judge at the end of the trial, that while he shouldn't accede to what we characterised as the appellant's submission that Mr Cook had been lying, he needed to look at all the evidence and come to a decision which took into account all evidence in a balanced way. And then going across the page, I think my learned friend most likely cited this to you yesterday, second short full paragraph starting in these circumstances, and then they say, if the judge is to consider the situation, then however we turn to consider the manner in which the power which we assume in theory to exist was actually exercised in practice. The position is quite different. We've already set out the history. It's sufficient to make the following points, and my learned friend took you to some of these yesterday, but I would simply identify in relation to this, E, we say serious allegations were being made against Mr Cook, and going over to page G, they were relying on parts of it, Mr Cook's statement, in relation to category 1, albeit not the rest. Then on page 42, it now seems to us clear, and this is just below G, that fairness to the defendants and to Captain Belushi demanded that if a new case was to be advanced, this could be only upon the most stringent terms, including bare minimum opportunity for Captain Belushi to hear his credibility put in question, to defend it. And then finally in the conclusion section, page 51 please, they deal with the alternative basis if they hadn't reached the conclusions they did, which didn't deal with Captain Belushi. Bottom of page 51, second column, we could not, for the reasons already stated, fairly have dismissed the appeal on that basis, and for the reasons already stated would have ordered a retrial so that the truth of Captain Belushi's story could be tested in the light of a properly formulated case. Captain Belushi would have an opportunity to answer. They don't need to do that because that's not their conclusion. So, my lords, my ladies, in our submission, if you find in this respect that there is an issue in relation to the judge's findings about Mr Cook's evidence, then it would be appropriate to have a retrial rather than for you to step in and make the finding, when all these unsatisfactory matters could be dealt with. And if we look at the question of delay, which we have each provided a number of authorities on, but may I refer you, please, to Bond versus Dunster, 226, divider 14. Judgment of Lady Justice Arden.
You now moved on to the delay in the provision of the judgment.
I just, there's a laid point, so I just wanted to deal with it.
Yeah, no, sure.
I mean, we accept that there has been significant delay, and we accept what my learned friend has said, that Lord Justice Mells observed that there are bits in the judgment that seem disjointed. And if you conclude that that's as a result of delay, you have to consider, first of all, there's two challenges. One is Mr. Cook and the GPS. And my submission is that while you may disagree with the judge's findings, there it doesn't appear to have been delay, because he had Mr. Cook's statement and the GPS. So it wasn't that his memory of the evidence had dimmed, it was documentary. And in relation to the finding about the date on which the whole appeared, I'll take you to that in a little detail. But again, if you were to find that that decision, which is the factual finding that's appealed, with that in relation to Mr. Cook, was problematic, had been affected by the delay, then in my submission, this authority is relevant. And I'd simply refer you to paragraph 7 on page 228, and the
So this is a delay of nearly 2 years.
yes.
We considered it reasonable recently.
I mean, I suppose
This is the point, that delay of itself can never be a ground of appeal.
No.
It's got to be, it's got to be demonstrated that the delay had an impact
on the finding.
an adverse impact, effectively, on the
And
judgment.
I don't think that's in dispute between us.
No.
Just looking through this paragraph 7, it doesn't seem unfamiliar.
No, I'm sure it's not. But if one looks at the last part of the paragraph, the last two sentences. Sorry, not the last two sentences. If we start, if the reviewing court finds the judge's recollection of the evidence is at fault on any material point, then, and the error could not be due to delayed delivery of judgment, it will order a retrial if, having regard to the diminished importance in the circumstances of the special advantage of the trial judge and interpretation of the evidence, it cannot be satisfied that the judge came to the right conclusion.
Well, this is in a line of cases, and I remember dealing with an appeal that followed it, where the effect of the judge's assessment of the honesty and integrity of oral evidence, witnesses he actually saw or she saw, has been adversely affected by the passage of time, and so you're into the realms of Faggi and Shabani and not interfering with primary findings of fact made by the judge, because the judge has had the opportunity to assess the evidence. And if you can get past the difficult hurdle of impugning the judge's assessment of the evidence on the basis that so much time has passed that he or she has forgotten something material, which happened in the other case, the name of which I've forgotten, but since this one, then of course you send it back, because you've got to go back to the oral evaluation of that evidence.
Yes.
But this is a case where we're not dealing with an evaluation of what Mr. Cook's behaviour was like on the witness stand. This is a case where Mr. Cook isn't called, and it's a square contest between his Civil Evidence Act statement and independent evidence that was created contemporaneously. So why isn't this court in as good a position to evaluate it as the trial judge?
My lady, I agree in relation to Mr. Cook's evidence, and that's why I say delay isn't a factor there.
Yes.
But my learned friend, or the appellant, does identify delay as a factor there. if you were to agree with that, then it might be an issue for retrial.
Yeah.
More substantively, they also challenged the findings in relation to the date on which the whole developed. And that was based on the evidence of the two experts, Mr Kettridge and Mr Hopwood.
Yeah.
And, of course, the judge will have seen them both give evidence.
Yes.
And so if you were willing to overturn, and I'll take you to the relevant parts of the judgment, on the basis of delay, and I entirely agree with my lady's summary of the position.
Yes.
If you feel that because of the delay he lost the necessary advantage of making a distinction between the experts, then on such an important issue, it would be a question for retrial.
Right. That's all we need from Lady Arden's case.
That's all we need, no more, my lord. And
Right.
that was the only citation that I wanted to take you to in relation to delay, because I think everything else is agreed between the parties, as summarised by my lady. If we look at page 99 in the core bundle, please. He considers the evidence of the two experts, and he identifies in relation to Mr Kettridge what he says in his report about rodents. I'm sorry, we've had to come to rodents. And he then deals with citations from the transcript which Mr Kettridge said in relation to the rodents, and I will give you, I don't need to take you to them, but they are accurate citations from the transcript. And then he identifies that Mr Kettridge was not familiar with well-managed highways infrastructural code of practice at paragraph 82, which is the national guidance for highways. Mr Kettridge, having not been involved in highways maintenance since 1992, we see that at the top of paragraph 8. And then he says, nor did Mr Kettridge grapple with the important influence of the location of the defect and the assessment of dangerousness contained in the case law, the National Code of Practice and the DMA. And what he is referring to there is in evidence, Mr Kettridge was saying, if it's dangerous, it's irrelevant what the level of risk of someone coming across it is. And we see that in bundle B. At page B181.
To
B181.
181.
And it's lines 3 to 13. And there are lots of similar citations, but I don't need to take you to them all. That summarises Mr Kettridge's view. So he then had to decide between Mr Hopwood and Mr Kettridge in relation to the development of the whole. And he dealt with Mr Hopwood at 88.
So we're going back?
Back to the judgment.
No, back. No, sorry.
My apologies. I should have said
No,
that.
sorry.
Paragraph.
Paragraph 88.
Yes.
He says he prefers Mr Hopwood.
Yes.
And our submission is that if you look at his reasons, there was a sound evidential basis for that. and that if one looks at his findings in relation to the whole, which are at paragraph 108, page 106, he identifies at 1 and 2 the reason that he prefers Mr. Hopwood to Mr. Kettridge. And he finds Mr. Kettridge's explanation lacking. What I should point out is that at 108.3 his dates are erroneous because he refers to the 30th of October.
Should be May.
I'm so sorry, my lady.
Should it be May or April?
I think it should most likely be November. What he does do is at page 105 of the judgment, paragraphs 99
That's why I asked if it was May.
well, May would predate.
Yes.
He deals with the
13th of June. 6th of October. Isn't on the 30th of October. I can't see a reference to 30th of any month in this chronology. Something's gone wrong because
well, my lady, my submission is he's properly identified the chronology at 99.
yeah, but if you look at paragraph 100, Robin Nodes was unable to see the hole, but on the 6th of October, Mr. Kettridge visited and found the hole present, right? So that's on the 6th of October. And then you've got a finding that it wasn't detected on the 6th of October at 108.3. Well, those two don't make sense.
Anyway, after it had been filled in, post-accident,
Yes.
Doesn't matter.
doesn't matter very much.
No.
Well, it matters in instance, my lord.
And then we've got the finding at 102. There was a joint visit by both sides during which the hole was excavated, and it was common ground that the hole was composed of decaying roots from a tree which had been removed, as well as the rodents.
The reason it matters, my lord, is the hole reappeared. It got filled in and then reappeared. And that's why he identified that the change in the hole was consistent with rodents, which is why he preferred Mr. Hopwood's explanation to Mr. Kettridge's, which was simply it must have been there for a long time because it was quite big. And he relied in particular on the visit in June 2022 when he found inside the hole the rodent holes.
I'm terribly confused by this because if there's common ground at the time of the inspection that it could have been subsidence caused by removal of a tree, which we know was there and was removed in 2005, and that the rodents have got in as well, then the fact that it might have been rodents subsequently making it bigger or smaller doesn't seem to me to affect what caused it in the first place.
Well,
So it's very difficult to treat this as a freestanding point. I don't think, in fact, it's one of your respondents' notices points. But Mr. Hop, as Judge's paragraph 104 makes clear, that Mr. Hopwood considered it relevant that the very high experienced highways inspector, Mr. Cook, did not detect a hole on the 13th of February.
Yeah. And that
but
the grass
that does not
report
feed,
it.
he's just reciting the evidence there, my lord. That doesn't feed into his reasoning.
No, but in Mr. Hopwood's approach is clearly influenced, does it? Why would it not be by the witness statements which he was given?
Yes.
That's what experts do. They're given the lay witness evidence and said, give us your expert view.
But Mr. Cook's witness evidence was in, so...
Also, Mr. Weitzman, I'm not sure that I would agree that it doesn't affect the reasoning, because you've taken us to 108, 1 and 2, and both 1 and 2 are presupposing that there was an inspection and the hole wasn't there, and then the experts are giving different views about that. Mr. Hopwood said that it could have been created in that time. Mr. Kettridge said it couldn't have done because of its size. So it's all based on the underlying issue. Was there an inspection? Was the hole there on the 13th of
My
February?
lord, I don't accept that, because if you look at 109...
But just look at 1081. The only relevance of the 13th of February was that that was the date of the alleged inspection.
But he has to make... Sorry, I'm very grateful to my lord for raising this. He has to make that finding because he has to determine whether at the time of the inspection... He has to determine two things in relation to the inspection. Whether it was done, and if it was done, whether it was competently done. So he has to make a finding about the status of the hole on the 13th of February.
Yes.
Because the claimant's case is, it was there, and if he did the inspection, it was missed.
So it is relevant to his reasoning.
The fact of the inspection is that he is not relying on Mr. Cook's inspection record to make his finding as to the presence of the hole.
Not overtly in 108, no, because instead he's relying on what the experts
Exactly.
have taken that ball and run with it. Well, Mr. Hopwood has, and Mr. Kettridge says no.
Yes, but if you
So
look
it's
at...
very difficult to divorce it from the underlying evidence from those experts.
My lord, if you look at the reason that he prefers Mr. Hopwood over Mr. Kettridge, it is nothing to do with there having been an inspection at 1081. It is simply with the dynamics of the formation of the hole, which has nothing to do with Mr. Cook's inspection report.
Right. What further topics have we got to cover?
Two further topics, my lord, or three. My learned friend this morning identified a number of authorities which went to whether parts of statements could be omitted, Lucas directions, all evidence being the golden rule. We've dealt with those in our skeleton, and I don't propose to go through those authorities in any detail. In our submission, they don't assist because none of them are dealing with the situation here, which is 32.5. They're dealing with oral evidence, or in the Towery case, where a party applies under CPR 32 to cross-examine the other side's witnesses on the basis that they're giving hearsay. So they don't assist in the determination of this issue, which is dealt with, we say, by McPhillamy and Lafiltrata Legacy. Two more issues linked. One is expert evidence and the other is contributory negligence.
The last one was what?
Contributory negligence.
Contributory.
And I hope I can deal with this very shortly. It's absolutely right that there was a case management decision for cycling safety experts. And it's right also that we suggested it, although in my submission the appellants would have asked for it in any event. They instructed Dr. Davis, we instructed a Mr. Franklin, they met and provided joint statements. We did not consider at trial that evidence in any way assisted the judge. And we did not consider that to be the case because they failed to provide expert opinion evidence in a sense which would make it admissible. because all they were doing is telling the court what a reasonable cyclist would do, and that's not something the court needs expert evidence on.
What were the terms of the case management order?
That each party had permission to rely on an expert in cycling safety.
Yeah. How does that differ from what they
So,
How does that differ from what they did?
I'm not saying it did, my lord. I'm saying that in the end, all they produced was opinion evidence about what a reasonable cyclist would do.
And that joint statement, was that before the judge?
Yes, we did not rely on Mr Franklin.
No, I understand that. But the joint statement was something before the judge.
Yes.
And did that deal with whether a reasonable cyclist would cycle on the verge?
Yes. As did the evidence given by Dr Davies.
But the joint statement did.
Yes, there was disagreement about that, I think, in the joint statement, but we didn't call Mr Franklin to give evidence.
But there was disagreement about that.
There was
So
disagreement.
do you have a page reference?
Yes,
to
I
the
certainly
joint
do.
statement? Sorry.
Yeah.
20. Divided 20 in bundle A. Page A185, behaviour of the overtaking pedestrian.
Yeah. So it was a matter on which they were disagreeing, 7.1. Dr. Davis gave evidence, Mr. Franklin didn't.
Yes.
Thank you. Sorry to interrupt.
My lord, going to the authority bundle, it's our submission that what the cycling experts had to say about what was or wasn't reasonable was not expert opinion evidence which the court could take into account.
But then why was the order made in the first place? How can you consent to not appeal, not challenge case management order that these two experts should be called, and then at trial say that the whole thing it was ordered inadmissible?
Well, my lord, the fact that a case management order was made doesn't determine the character of the evidence or whether it's admissible or not.
Right. But the joint statement does, and the joint statement identifies there was an issue about this.
Yes.
So we've gone beyond the Master's general order, haven't we? We've got to an identification of an issue between the experts.
Yes, but if I can take you to the authorities, that will answer the question.
But just before we go there, so just so that I understand, how did this challenge first manifest itself?
In my skeleton, I raised the issue, and we can see that in bundle
In your skeleton
before trial.
for the trial,
Yes.
you raised the issue,
That this was opinion evidence which was not admissible.
right?
And then I did not call Mr Franklin, the respondent's expert,
Yes.
and after I then I made submissions to the judge that Mr Davies' evidence was not of assistance.
Right.
That's how the issue arose.
And the judge, you made submissions before Dr. Davies gave evidence?
No, after.
Right. But surely you needed a ruling that Dr. Davies' evidence, if it was inadmissible, shouldn't be before the court.
Well, he gave evidence, and then I made submissions on the basis of the evidence he had given to see whether it was of any assistance to the judge or not.
I don't follow this. The joint statement was before the trial.
Yes.
And then you don't seek to say to the judge this man shouldn't be allowed anywhere near the witness box because whatever he says is going to be inadmissible.
Yes.
But then you make submissions at the end of his evidence that everything he had said was
Well,
inadmissible.
but my lord, what I explored with him in his evidence is the basis on which he was giving the evidence. And he said he was giving evidence on the basis that this is what a reasonable cyclist would do.
Yes.
And my lord, that's not expert opinion evidence which is admissible.
Then why were these two people instructed in the first place?
Well, my lord, I would agree with that comment, but I wasn't there at the case management hearing. But you,
at the moment, it doesn't seem to me that you're entitled to raise this. I don't mean you, Mr. Weitzman. I mean you on behalf of the defendant.
my lord, there's a difference between a case management ruling giving permission and the contents of the evidence and whether it assists. And if it is simply opinion evidence about what people normally do, if you have a road traffic expert saying he was driving in this way and I think that's negligent, that doesn't assist the court.
The evidence having been given, because it wasn't challenged before it was given, then does it become a matter for the judge as to whether he finds it helpful or not? I mean, I take the point about the case management conference, but we've got far beyond that.
I agree, and in my respectful submission, you point out to the judge what the rules governing the evidence are, and then he has to make a decision. But what he can't do is rely on opinion evidence which doesn't assist him.
Does anybody have a copy of the case management order?
It's in the bundle.
Could we see it?
It's at A24, divider 24. And the relevant page is A206.
Cycling safety.
Are you saying that Dr. Davis and Dr. Franklin were not giving evidence about cycling safety?
No, my lord. I'm saying that they were giving evidence about what a reasonable cyclist would do.
Yes.
And there is no scientific... that does not assist the tribunal because it's a matter of common sense. And so expert evidence is not required on that issue.
Were they not giving evidence about what it would be safe for a cyclist, the reasonable cyclist faced with the situation in which the claimant found himself to do in those circumstances?
My lady, they were, but that's just like saying what would it be safe for a motorist to do? And the court doesn't need that evidence, and I'll take you to the authorities to deal with that. Can we go to the authorities bundle, please? Can we look at Kennedy versus Cordy at 17? Page 296 and 297. And it's the citation from the South Australian case of R versus Bonifan. And if you can read the citation including A, B doesn't assist.
this is very familiar territory, but we're not here considering an appeal from the order of the master that each party should be able to call one cycling means.
I accept that, my lord. But in my submission, the issue that the court should be concerned with was whether this evidence added anything at trial, or whether it was simply opinion evidence of what a reasonable cyclist would do. And if it is, then it doesn't assist, and the judge should not have taken it into account, which in our submission he did. We're making the finding we've already been to, that it was reasonable to cycle on the verge, albeit elliptically. If we go back in the authorities bunch, if we look at paragraph 45 and the citation from Wilson versus HM Advocate,
Sorry, as ever, I'm behind you.
no, my lord,
Tab and
no,
page.
it was paragraph 45. It was the citation from Wilson versus HM Advocate.
Oh. Yes.
And in our submission, unless the evidence adds scientific information or expert information which would otherwise be unavailable to the court, applying the criteria Lord Reed is there setting out, it doesn't provide the basis of admissible opinion evidence. And the clear example of that is Little versus Middleton, which is behind divider 5, pages 64 and 65. And if I can ask the court to look at the red lining on 64 and the top of 64, the position there is clearly set out by Lord Justice Stuart Smith.
Lady Justice Janet Smith, actually, not Lord Justice Stuart Smith, but anyway.
Sorry, my lord.
Is it?
If we can,
Stuart Smith LJ at
Does
page
it?
59.
I'm sorry. Anyway, both expert in the fields of personal injury, of course, all this is correct.
well, my lord, we simply say that if the position is as it was, and I'll take you to the references in the transcript, that Dr. Davis was simply saying what we all know, simply saying what a reasonable cyclist would do based on common sense, then it doesn't assist the court, and the court should not take it into account. Because in effect,
And the judge should then have either rejected it or ignored it and
Indeed.
reached his own common sense conclusion
yes,
to the contrary. Yes. All right.
I mean, it would be as if I called a highway engineer to say this is the right way to drive. I mean, we all, in fact, on the first day established that we'd cycle to court that morning.
But I don't see where this point goes, because assume you're right and the judge shouldn't have had regard to this evidence, you still need to say that the judge's finding was wrong.
If he's taken into account evidence which is inadmissible in relation to the finding about whether it was sensible to cycle on the verge or not.
Yes, but for the point to go anywhere, don't you need also to say that
No,
if he'd not
no
had
reasonable
regard
judge.
to this material, then he would have found that it was an unreasonable thing
Well,
to cycle on the verge.
then in my submission it becomes a question for you to consider.
Come a question.
For this court to consider. If he's based himself on Dr. Davies, which he appears to have done.
Well, I'm not so sure about that, Mr. Weitzman. I think you have to go so far as to say that no reasonable judge faced with this information could have found that it was appropriate for the cyclist to go on the verge.
Well, my lady, surely the question is not if he's taken into account inadmissible evidence and he's made a decision on that basis, that undermines that decision as a matter of law.
If he could have agreed with the evidence or could have formed that view for himself, why does it matter?
Well,
It's only if he couldn't have formed that view for himself that it matters.
my lady, surely it matters because if he didn't form that view for himself, and that is what he should have done, then he's relied on evidence which he should not have to come to a conclusion. So, and can I take you please to B299, which is Dr. Davies' evidence. I'm just going to give you the line references. Line 12.
Just a minute.
My apologies. B299, line 12 to line 15 on B300. And then B304, line 24, and the whole of page B305, please. And my lords, my lady, if we're correct about that, and you find for the appellant, we say that goes to the issue of contributory negligence. We set out in our skeleton why we say it's relevant, because again we say he relied on Dr. Davies to find that this was reasonable cycling.
So you say that the expert cycling evidence, you say inadmissible, is particularly to the judge's assessment of contributory negligence.
Yes, because he finds when he's dealing with contributory negligence that it's reasonable for him to cycle on the verge. But in the end, that's a matter for you, in my submission. It's not a matter for expert evidence. If you all consider it was reasonable for him to cycle on the verge, then it takes me nowhere.
Right? Was that the last point or the
That's
second?
the last point.
That was the last point.
Those were two conjoined, my lord.
Right. Thank you very much. Yes. Does your junior follow?
No, my lord.
Right. Thank you. We'll rise for 10 minutes before reversing to Mr. Porter.
Court rise table.
the street.
Is the court ready?
Oh yes.
Court riser Fable.
Mr. Porter, to take Mr. Weitzman's last point first, we need not hear you on the subject of the cycling experts or their views on influencing the judge on contributory negligence or anything else.
My lord, thank you. That will save probably a couple of minutes.
Yes.
I think there are some other matters in my my
indeed.
learned friend's submissions that I do need to comment on, and I'm conscious of the time, and I'll do so as speedily as I can. Perhaps I'll be forgiven if I don't go to particular references as slowly as I might have done if I'd had half the day to do it.
Of course.
But my lord, can I start with my learned friend's 8 propositions, which have come more or less out of nowhere and concluded with the extraordinary assertion, as we see it, that there is no scope ever for finding a breach of Section 41 of the Highways Act if the defect is on the verge. Now, I say I'm surprised because I don't recall the judge ever being addressed in that way. Now, there is a difference, of course, and this may be what's in my learned friend's mind, between his client's DMA, which your lordships will recall you were taken to.
Can you keep your voice up?
Yeah, I'm so sorry, Mara. I've a bit of a cold, so I'll struggle against those odds. It may be that my learned friend was thinking of his client's DMA, which apparently, in the revised view of Mr. Smith, there was no option for any highways inspector to have a Category 1 defect. But he never addressed the judge, as I recall it, on a point that one could never have a breach of Section 41 in relation to a defect in a verge. And I didn't even see that coming, I have to confess, my lords, my lady, from his skeleton argument filed in this case. It would require, I respectfully submit, suggest a very clear authority to lie behind such a bold proposition. And the best my learned friend has come up with, the cases of Kind and King, go, in my submission, nowhere to support that. And indeed, he's got the obstacle of the Court of Appeal decision of this court in Russell, which, as my lady, Lady Justice Andrews pointed out, rather seems to knock his point as a generalisation and as a matter of law without any consideration of the facts. You cannot have a breach of Section 41 if you're dealing with a defect in the verge. I say that's just so, that's what he comes to. It undermines the whole process by which he's got there, because it's an absurd proposition, and it's not one, frankly, that we've heard before in this case.
Well, it would only make sense if the verge wasn't part of the highway.
Yes, well, the verge is.
If the verge is part of the highway, then the question is, what is the obligation in relation to repair off the highway? And that must be a question of fact and degree in the individual case.
Yes, indeed, my lady. And it's Burnside, what is the ordinary traffic, which is a question which was considered carefully, certainly by his standards.
And there may well be plenty of cases in which you wouldn't normally expect traffic to be passing and repassing over a verge.
Yes. Well, your lady will recall that the first case cited, the Kind's case, was a farmer who was dissatisfied that he had to keep moving his tractor over because there wasn't enough room because he wanted the whole thing tarmacked. Well, that's so far from this case. I don't think I need to take it any further. And we have never said, lest there be any doubt about this, we have never said that a verge has to be maintained to precisely the same standard as a carriageway. That's something that my learned friend asserts, and is again quite extraordinary. He says a pedestrian can trip on a verge, and a pedestrian can trip on a paved part of a footpath. And what's the difference? Well, the difference is that the pedestrian knows where they are. It's self-evidently right that you do not maintain a verge to the same standard as the paved surface. I struggle, frankly, to see quite where that has come from. The judge was entitled to consider the verge as a verge and to consider all the circumstances, including that pedestrians and cyclists were using this path. It was a narrow path. His finding that it was entirely reasonable for a cyclist to go onto the verge in order to overtake another pedestrian, or it could have been a cyclist. But all that supports his conclusion that this was ordinary use of the highway and there was a defect engaging Section 41 of the Highways Act. And unlike the Section 58, a rather different point that depends now entirely on written evidence, this was all a matter for the judge, weighing up what he heard from all the witnesses, the DMA and the like. And it's not a matter, realistically, that my learned friend can challenge in this court with the bald assertion that he's provided that that the judge would be wrong to find any defect an actionable defect on a verge. So, my lords, my lady, I tend to just take that, given the problems of time, to just take that, leave it there. But obviously, I'm very willing to try and assist further if that's required. My learned friend went then to the common law duty of care. He went to his own case of Yetkin, with which, of course, he's very familiar, and he took the court, I won't take you again, to paragraph 32, which confirms, in the words of this court, that you do not need to apply too literal an interpretation to Lord Brown's examples given in Gorringe and the trap and the like.
Sorry, paragraph 32.
It's paragraph 32 in Yetkin, which is the highways case that my own friend took you to and was involved in. He took you to the cycle infrastructure design document, which we have at A1, and again, without, unless the court feels it necessary, taking you to that document, he perhaps didn't emphasise in the way that I would, that the guidance in that document at A7 in our bundles, 3.4.2, says that end of cycle lane signs are rarely required. A point I made in my skeleton argument. That doesn't mean that they're never required. And where one asked rhetorically could be they're more self-evidently required than when a cycle lane merges, not into anywhere that a cyclist is entitled to be, like a road or a bus lane or anything like that, but into a pedestrian path where the cyclist is not entitled to be and where the appellant would not have been if there had been such a sign. I don't want to take unfair points against the learned deputy judge, and if my learned friend tells me that he was supplied with the later copy of the Highway Code, then of course I accept that. But I do recall providing him with a copy of the Highway Code that was in force at the time, because I hadn't had it with me in court throughout as I have it here. But I do retract then, having said that it was researches of his own, if the wrong version had come from my learned friend.
Yes.
What I think Melanie said. So I happily retract that, but of course it makes no difference to anything. The attempts to distinguish the words of Lord Brown in Gorringe, in my submission, came to nothing. Your Lordship will recall that I criticised the judge for saying, well, cyclists know that they shouldn't be on a cycle lane, so therefore you don't need to sign it, which makes no...
Not on the footpath.
Sorry, on the footpath. That's precisely why you need the signs. My learned friend was trying to draw a distinction between a danger that arises because he's using the cycle lane and a danger that arises because, in his words, he's chosen to leave the cycle lane and go on to the verge. But that is precisely a function of the cycle lane being too narrow to be a satisfactory piece of cycling infrastructure. So it is exactly like Lord Brown's example of the one-way street in Gorringe. And I said in my skeleton argument, or we said in our skeleton argument, we wouldn't say that it would be sufficient, for example, if the appellant had been cycling along that path and had been squashed by a tree which had fallen over, for which the respondent was not responsible. In other words, it wouldn't be sufficient if it was just coincidence that he was there. He should have been prevented from being there, and then something completely different happened to him. It's Lord Hothman's famous example of the medical doctor who advises someone they can go mountaineering. What we do say is that this danger was plainly linked to using a narrow cycle track that was alongside an unsuitable and inadequately maintained verge. And the learned judge was absolutely right in his finding and point that it was entirely foreseeable, entirely reasonable for cyclists to overtake another path user by going on to that verge. So it is precisely the danger.
Right about that.
Sorry?
So if the judge was right about that, what does the common law claim add?
Well, I've added the common law claim because my learned friend says...
I appreciate everybody deals with everybody else's point.
Yes.
You're the claimant. What does it add?
Well,
I'm baffled as to what the common law claim adds.
My lord, if I lose this case because I put in evidence Mr. Cook's statement, for example, then I don't lose the common law claim because that has nothing to do with Mr. Cook. That has to do with the respondent's failure, I have to put it a positive way, just as in Yetkin, the failure to crop the vegetation was put in a positive way. It is arranging a scheme, which my learned friend accepted in his submissions as a positive act, without any signage to indicate that the cycle path that had been created stopped at a point where you'd have to be a highways engineer or expert to appreciate that it stopped in the absence of any signage that it had stopped. So that's the common law duty. It's akin to Lord Brown in Gorringe.
You wouldn't realise that the cycleway had stopped because suddenly it narrowed into a footpath.
Precisely.
You wouldn't realise that.
You wouldn't.
Unless you were a highways engineer.
Exactly.
I would.
Well,
and I'm not a highways engineer.
Well, my lord's a judge, which may...
I know, but it's a very narrow footpath.
It's very narrow, but there was agreed evidence from the highway only one of them was called. But according to Dr. Davis, I think this is in the joint statement, the width of a path is no indication of its status as a cycle lane or not. And that is because there is a lot of unsatisfactory, perhaps older infrastructure out there, which has not been upgraded. We never did get a full satisfactory history about whether there'd been an unsatisfactory cycle lane all the way up the A10, and then it was upgraded up to the Portcully Bridge, not beyond, or whether something different was done.
I thought it was the other way. I thought it was a narrow path that was then added, because in one of the photos, I think you can see the join in the
Absolutely.
concrete.
That's physically what happened. There was a bit of discussion we haven't had to go into in this court about the status of the path, because I haven't challenged the learned judge's finding that it was in fact a footpath north of the North Cully Bridge. In fact, if one looks at the evidence, there's nothing in the respondent's possession that indicates any difference between the orders they made in relation to the path south and the path
Anyway,
north
Mr.
of
Porter,
the
your answer to my question is this matters because if I lose on Mr. Cook and the Section 58 defence, then I can have a common law claim because the common law claim's got nothing to do with Mr. Cook.
Exactly, my lord. I only have to win on one of them. Perhaps I should have made that clearer when
Yeah,
my submission. I only need one to succeed. My lord, next, my learned friend went to Mr. Cook and he questioned why I didn't ask Mr. Vine about the GPS data, which would, well, didn't seem to me appropriate, seemed to be probably futile. And of course, at that point, I did not realise that the application to put Mr. Cook's evidence in under the Civil Evidence Act was going to be abandoned. So I was waiting. You may well wonder, the court may well wonder, well, what on earth was Mr. Porter doing raising these questions with witnesses in cross-examination? He might have been better off just keeping quiet. But if they'd been ideal witnesses, Mr. Alan Smith in particular would have perhaps acknowledged at a much earlier stage than he did that his highway inspectors would have treated this as a category.
Sorry.
This was a category 1 defect. I'm so sorry if my voice is dropping, my lord. In which case, I could have carried on opposing the application to put in Mr. Cook's statement. I'm not sure I saw it in quite the same way as my learned friend. I didn't think his application was necessarily going to fail. My understanding is that we've moved on since the 1968 Civil Evidence Act, addresses one of my lord's points, that you no longer have to demonstrate that your witness is dead or beyond the seas, but it's all a matter of the weight that the court attaches to the statement. I think that's the 1995 Act, if I remember correctly. So there was no absolute bar to him putting that evidence in. One strongly suspects in front of this judge, one strongly suspects that he might have succeeded on that application. He certainly would have had good chances of succeeding on that application if I had not opposed it, which would have been the situation.
Anyway.
Sorry?
There was a risk.
Yes. Well, lady, just getting to Mr. Vine, where we were at that point, had I got some more clearly open and honest answers from Mr. Vine and Mr. Alan Smith, it may well be that I'd never have got to the point where I had to start relying on Mr. Cook's evidence. And had I got to that point, the thought at that stage, rightly or wrongly, was that it would be a matter of not opposing my learned friend's application to put the statement in, because it appeared, rightly or wrongly, to us, that Mr. Weitzman's Section 58 defence didn't have a lot of chance of success without the evidence from Mr. Cook. But conversely, and I do say my learned friend protests, as he did below, he protests the case hadn't changed. I think couldn't take a pleading point on it, I quite agree, because every learned pleader of a defence to a Highways Act claim will mention Section 41 as well as Section 52. But the evidence that had been served from his witnesses was, well, this is a defect. had it been seen, would have been categorised category 1, would have been dealt with, would have had a plate on it. Therefore, we've got a good Section 58 defence. Not terribly consistent with saying, well, as a matter of fact, a whole of that sort does not amount to an actionable defect. And the Highways Inspector, Mr Cook, would have been quite justified to write exactly what he did about a series of category 2 defects on the verge. I was yes, I take this very briefly, and I've left most of the submissions on this and Mr Cook to my learned junior, which I'm very grateful. But, can I just be clear that I did not accuse Mr Cook of lying? Now that we know that Mr Cook remained, as far as we know, remains completely unaware of the content of the document with the GPS timings. Still less would I be suggesting that he's necessarily lying either in his witness statement. Well, that's what matters, in his witness statement. The highest my learned friend could put it is that, well, he must have known that his employers expected him to do a walked inspection. And without telling his employers, we assume, he did a driven one instead. That's as far as the dishonesty that my learned friend is suggesting goes. When he repeatedly says that Mr Cook falsified the document that is the Highways Inspection report, it doesn't refer to a walked inspection, it refers to a driven inspection. So, had we got to the trial, had Mr Cook been there, as he should have been witness summoned, he might, as my lady said, he might have readily accepted, oh, I see from these timings, something went awry, maybe I was pushed for time, maybe I just didn't on that occasion.
I carried out an inspection, but it wasn't as long as I thought it was.
Yes. We don't know because he wasn't there. I mean, whoever's fault that is, it's certainly not the appellant's. And the idea that he should suffer through the loss of his claim because of these arid debates about whose witness we've got and who's allowed to do what, must seem very, very puzzling. I think I'll have to go back to the transcript my learned friend took you to and the debate with the judge, because although I accept this B133, I think I want to get there was no formal ruling, and the great benefit of hindsight. Perhaps something, I were doing it again, I would have pressed the learned judge for, although I am going to explain some circumstances that are relevant to why I didn't. If you're at 133, first of all, the deputy judge asks Mr Weitzman, has Mr Anne Smith seen the witness statement? We're discussing that. Mr Weitzman says he doesn't know the answer to that. I suspect he has. And then the deputy says, you suspect he has. I think, Mr Porter, you're going to have to put the questions you wish to ask in writing. If you wish to do this line, he says, I'm not going to exclude you. I'd like opponents' comments on those questions, and I can decide overnight, etc. My lords, my lady, I had already made it very clear that I made it very clear to my opponent outside the court door and to the judge that what I wanted to do was put to Mr Anne Smith the content of Mr Cook's witness statement relating to categorisation of the defect and the temporary protection of a plate and so on. I was told that I wasn't going to be allowed to do that unless I put my questions in writing, shared them with my learned friend, and waited till the following morning in order to put them to the witness. We were very pressed for time in this case. I don't know whether that's an explanation or an excuse. And there was a rail strike due the following day. There was all sorts of questions about who was going to be able to get to court for day 3 of 3 days we had set aside for this trial, which was already overrunning. I was anxious, rightly or wrongly, to find a solution so that I could cross-examine Smith while he was there, and without going through the process. So I don't think the judge, with respect to him, was entitled to require of me to go away and put down in writing the questions that I'd made very clear what I wanted to put. And I don't know if they made a distinction today that he hadn't made before, and certainly not in front of the judge. Cross-examination as to credit and as to the content of the witness statement. So on page 134, line 4, I wanted time to reflect. I say it's most convenient for the reasons I've just explained, and if I'm to do it, I do it now. And I would have thought it would be on any view acceptable for me to ask this witness, given what he said thus far, whether he knows how the particular highways inspector would have classified this defect. And that might not require reference to this statement. Of course, it might have done, given the way in which Mr. Smith actually answered. Perhaps it would have required me to then put the statement in. But all of it, was objected to by my learned friend. And in order to try and find some solution to this problem, I tried to get an assurance from the learned judge, which I thought I had, that I would not be bound by the whole statement, put different weight on different aspects of it, and particularly a distinction between the self-serving and the less self-serving part of the statement. And neither the judge nor my learned friend, by way of inviting any sort of ruling, said, wait a minute, if you do this, you've got to accept that even in the light of whatever alternative evidence there might be, you've got to accept that Mr. Cook did a walked inspection.
That was Mr. Weitzman's submission.
Yes, well there it is. I just try and
Yeah.
explain where we got to that stage and how it was that we ended up where we did. I'll leave that and come on to the next point, which does cause concern, certainly to those behind me. Mr. Karpasitis has more limited resources, perhaps, than those who ensure the respondent counsel.
Yes.
But the idea that there should be a retrial fills us with horror for all sorts of reasons. So not just the expense, but because we're still going to have unresolved problems. What on earth do we do with Mr. Cook next time round? The issue with Mr. Cook is entirely one on the papers. We've got his statement, got the case law, got a transcript of what went on before the judge, and I respectfully submit that a retrial would be a very unfortunate outcome, which is completely unnecessary in this case, and I would urge the court
Yes,
to
but
overturn
what we want you to
Yes.
say on the Mr. Cook issue is
Yes.
the proposition neatly put by Mr. Weitzman, transcript B140, first paragraph, is that you were trying to have your cake and eat it, and that as a matter of law you could not put a challenge to the witness on the basis that Mr. Cook's statement was inconsistent with theirs, except query, doing it as it's done in the Crown Court by showing the witness the document saying, don't say anything, do you agree with that or not? And if he says, I don't agree with it, then you cannot rely on it or refer to it in any way, shape or form. That is what is said to emerge from Property Alliance and CPR 3255.
My learned junior has dealt with the law, and I hope, confident, satisfactorily. But what I can say about this is that what my learned friend was saying about cakeism was relating to trying to put the statement to a witness, or part of the statement to the witness, parts of it, and not arrest. So I put to my election, I could put in the whole statement, or put in none of it. That is all subject, as I understood it, right or wrong at this stage, is all subject to an indication from the judge that different weight be attached to different parts of this statement. That's what I thought I had. That's where I thought we were. So, as I say, a few lines later, just after the cakeism reference, I say I make this very clear before I put it in, that I will address your lordship as to its weight, and the respects in which it's, as it were, self-serving, which may differ substantially from the weight to be given to those parts which I'm about to put to this witness, which are not so obviously self-serving. Then I complain again that Mr. Cook had no arrangements to be made for Mr. Cook to turn up and give evidence. Nobody was saying in terms, either judge or my opponent at that point, that this was, if it went in, was going to be evidence that bound me and my client and prevented me from making submissions against weight on the basis of the GPS data.
I mean, the irony of all of this is that if Mr. Weitzman had persisted in his application to put in the evidence was hearsay evidence, you would have had the right, under the rules, to say, I can now call Mr. Cook as a witness and cross-examine him.
Indeed.
As if he had been called by Mr. Weitzman and given his evidence live.
Indeed. Well, my learned friend says the objection to his Civil Evidence Act notice was never withdrawn, but it's the other way round, actually. His Civil Evidence Act notice was withdrawn, as he told me, during the interval when he'd taken instructions on the map from
I mean, was it ever part of your plan, if that hadn't happened, to say to the judge or make submission to the judge, well, if my learned friend is going to put in his witness statement and my objection to that is overruled, I want him to be called so that I can cross-examine him?
Well, my lady, it might even have been, I won't object to my learned friend's application.
Provided he's called.
Provided I can cross-examine him.
The rules on that are very clear, and you're right.
Yes.
There is no longer a tie to, under the new Act, or the most recent Act, there's no tie to the old categories of reasons. The rules simply provide that you have to be told what the reasons are why the witness isn't coming.
But it was as court will understand, with some horror, having thought we were when we were, with the weight that the judge said he would attach, and then get a judgment that, although it said that it attached different weight to different parts, actually accepted the whole of it, except arguably, as my own juniors pointed out, arguably the bit that we wanted it in for about category 1. That's a point I suppose I will need to come to as well. I don't think there's more I can usefully say about retrial apart from to urge the court to do it only as a very, very last extreme, which is not necessary in this case.
Well, have you covered the point that was made by Mr. Weitzman about the? I think he accepts that the Cook point is one that we could decide for ourselves, but he says, well, the judge also placed reliance on the expert evidence, and he preferred Mr. Weitzman's expert to your expert, and that isn't something as an exercise that we can do, and that has a factor into the whole question of whether there was a defect, and if so, whether Section 58 defence has been made out.
Well, I fall back on my submissions that I made yesterday, my lady, that none of this becomes critical once it's found that the defendant has no inspection to rely upon. So Section 58 doesn't get the respondent anywhere. Maybe worth just turning that up. Just to remind ourselves for a moment of what Section 58 says, and it's the Authorities Bundle, page 5. Section 41, of course, there is a duty to maintain the highways, and we've argued about that. 58 provides that there's a special defence for non-repair of highway to prove, and this is the authorities' burden, mainly. This is halfway through subparagraph 1. To prove that the authority had taken such care as in all circumstances. It was reasonably required to secure that the part of the highway to which the action relates was not dangerous for traffic. And then for the purposes of the defence under subsection 1, one looks at the following matters that the learned judge to some extent looked at. And of particular relevance in this case, once the sector, A, the character of the highway and the traffic expected to use it, and E, where the highway authority could not reasonably have been expected to repair that part of the highway before the cause of action arose, what warning notices of its condition had been displayed. But for the purposes of such defence, it is not relevant to prove that the highway authority had arranged for a competent person to carry out or supervise the maintenance of the part of the highway to which the action relates, unless it is also proved that the authority had given improper instructions with regard to the maintenance of the highway, and that he carried out the instructions. Lady, I go back to my submission in opening. We don't get to section 58 without Mr Cook's evidence. If we don't get to section 58, then the inquiry as to what the condition of the highway was at the time that Mr Cook purported to do his walked inspection becomes completely irrelevant. And as I said in opening, why that date rather than any other date? The respondent will have failed to discharge the burden of proving it has a special defence under section 58.
So that is the relatively, if you're right about Mr Cook, that could be your only possible way of avoiding a retrial.
Well, unless you're with your common law claim.
Well, leave the common law claim to
yes,
one
leaving
side.
that aside.
Because as you put it, in answer to my lady's question about the expert evidence, for example, you said none of that becomes critical because they have no inspection to rely on.
Yes.
So it comes back to that there would have to be effectively a finding that they don't get a section 58 defence off the ground because without Mr Cook there was no inspection.
Indeed. Yes, my lord. Yes. And as we said in our written opening, and as I think I said yesterday morning, even if we do get to some form of inquiry as to what the state of the highway was at the date that Mr Cook would have done his inspection, then the judge is left with the evidence from the experts, which certainly in the case of the respondent's expert, proceeds on the premise that he needs to find an explanation for how this hole has appeared, and it's a very large hole, how has this very large hole appeared between the February inspection, which he assumes to have taken place, and the accident in March.
Well, the timing of the appearance of the hole has a relevance to what steps, if any, the authority should have taken to do something about it. Because if it's there for 3 months and nothing's done, and there hasn't been a proper inspection, and it would have been adhered to, something would have been done along the lines of what Mr Cook said he would have done if he'd seen it. You can see that the case against the authority is a lot stronger, but I think what Mr Weitzman says is, well, my expert says this hole could have appeared overnight because it's potentially a case in which the rats or whoever, burrowing rodents, have undermined a soft verge structure which has been an accident waiting to happen for years because of the tree being removed, and therefore on the balance of probabilities it wasn't there in February, irrespective of whether Mr Cook got out of his car or not. I think that's the way Mr Weitzman puts it.
But then he's got a very convoluted cause.
I see Mr Weitzman is shaking his head.
My lady, the law is that if he didn't do the inspection, it's not for us to say, well, it wasn't causative.
Right.
So the point I make about the hole is he has to decide the hole to see whether the inspection was done competently, because if it was there, he would have missed it, and that would not have been a proper inspection.
Right.
But as a matter of causation, I concede that if he didn't do the inspection, it's not for us then to say, but the hole wasn't there, so even if he did it.
Right. That's very fair.
That's helpful. So I hope that answers
That must be
my
right.
lady's question.
That must be right. So thank you.
That's what I was saying. That you don't. You've got, the local authority has to engage Section 58 with a competent inspection.
Yes.
Absent a competent inspection, well, they lose. I'm afraid it's their bad luck if the hole has arisen the night before.
Right.
So,
I'm grateful for the clarification. Thank you, Mr. Wiseman.
thank you. So, I don't have to. I don't have to deal with expert evidence or contributory negligence, as I understand. I'm very grateful for that. Can I then just? I think the most time efficient thing for me to do is perhaps just speak to our written submissions on the respondent's notice, and obviously omitting the contributory negligence and the core bundle. We put our notice at tab 4, starting at page 31. I'm going to strike through ground 1 as unnecessary. Ground 2, I just repair. I've dealt with this to some extent because of what my learned friend was saying about his 8 points leading to
sorry.
conclusion. Sorry, say something.
Forgive me, Mr. Porter.
Yeah.
Can we just wind back 5?
Yes, of course.
You said without Cook's witness statement, one never gets to section 58. And Mr. Weitzman said, but you did put it in.
Well, yes, that goes back to the debate we've got about the basis upon which I put it in, and whether I'm entitled to rely on the apparently independent, apparently reasonably clear GPS data to so that the judge should have found that Mr. Cook did not do a warrant inspection.
You want us to find that that's what he would have found if you're avoiding a retrial. That was the point of my earlier question.
Yes, Lord, I'm grateful.
If you're right
I think
about the
this
first
court can determine whether the GPS data should have been given much greater weight than it was, and whether in the light of that data, the judge should have found that a walked inspection did not take place, and therefore, follows, section 58 does not arise. Retrial not required on any of the grounds.
It seems to me that raises a question independently of, because it's conceded under the filiatra legacy that a judge can make up their own mind one way or the other about a witness, irrespective of whether counsel's hands are tied in the matter. So does it go this far as you saying, well, leave aside whether or not I'm bound to accept,
Yes.
I'm Mr. Porter, am bound to accept
Yes.
the whole of Mr. Cook's evidence, warts and all. It's still a matter for the judge to make an evaluation.
Yes, exactly.
And the judge, faced with the GPS evidence, Mr. Cook and everything else, could and should reasonably have reached, well, couldn't have really reached any other conclusion, but that he was in error when he said he did the inspection that he said he did.
Precisely, my lady. One of the problems we have with the learned judge, we made these submissions to him, he forgot what they were, he required the further submissions 4 months later, etc., etc. For all sorts of reasons why his decision based on the GPS data cannot, in my respectful submission, stand, but none of them require a retrial. One question is what either the same High Court judge or perhaps more likely a different High Court judge will do with this information that this court can't do with that information. We've got the GPS data, we've got Mr. Cook's written statement, we've got the fact we now understand that Mr. Cook is in blissful ignorance of the GPS data that appears to contradict his statement. None of it would. There's no chance, no realistic chance, that Mr. Cook is going to attend a retrial, and this is a matter that can be dealt with here. with all the economy and speed that is associated with not having a mistrial. It's one of the ironies of this case. One of the reasons that I was looking for solutions to deal with Mr Cook's evidence was that if we'd gone over our 3 days in front of the deputy judge who was sitting that week, it would have gone off, and I hadn't realised, of course, that it was going to go off before we got a judgment for 9 months anyway. But there is some desirability in conclusion.
Right, sorry,
So-
I derailed your train of
Well,
thought.
not
You-
at all.
you have moved
I
on.
tried to just, I think, if I can, rather than go through every point in this response document, save a bit of time by hoping that the court will perhaps reread it. We do make the point, 12, that his findings on disrepair are fact sensitive, and he dealt with that part of his judgment, dealt with the facts suitably. I'm sorry I called it the Port Tully Bridge. It should be the Paul Tully Bridge. There's a very strange formulation in the judge's judgment about this being an urgent defect. It's not a Category 1 defect, and it's confusing and muddled. But I think the genesis of that muddled confusion is actually in the evidence of Mr Alan Smith. And can I invite the court, please, to turn up in the transcripts, Bundle B, page 92. This is all part of the passage of Mr Alan Smith, where I was trying to get him to accept, before I think we had Mr Cook's evidence, trying to get him to accept that Mr Cook would have noted a Category 1 defect. So he says at the top of 91, every confidence in Jeff, etc., etc. I think I've made this point before. But then, over the page, one takes this quite long answer. It starts at line 21 on B91 and go over the page. Can I invite the court to just read that passage from Mr Alan Smith's evidence?
Well, Mr Alan Smith seems to be persisting in the notion that the only defects on a verge are ever Category 2, which feeds into Mr Weitzman's submission
Yes.
about
but
ruts and so forth.
Yes, but my lady, he's slowly. I'm having a go at him. He's being very resistant to the suggestion that what he said in his witness statements. I take you to. I won't take you to again. Was inconsistent with what he was now saying about what Mr Cook would have done, and indeed his witness statement had implied, said that Mr Cook would have had the discretion to deal with the matter. That we didn't, from our side of the court, find these explanations by Mr Alan Smith very convincing or very satisfactory, but that's not to say that the judge didn't. And here Mr Alan Smith appears to be saying, well, it can be Category 2, but Mr Cook would probably have flagged it for a quicker check to see if urgent intervention was required. Mr Alan Smith is confused and muddled about urgent intervention in Category 1 and Category 2. It's not altogether surprising that the learned deputy judge was muddled in his judgment. I think that almost certainly would be the explanation for why the learned judge makes those rather curious findings. But it doesn't detract from the fact that the learned deputy judge was entitled in all circumstances to find that the whole present at the time of the accident was an actionable defect, which is what he found. It doesn't matter. Category 1 and Category 2 are not words in a statute. They're not words in section 41 or anywhere else. They're the internal workings of the highway authority. What the judge found is important is that it was a dangerous defect. Then there's no reason in logic why the judge wouldn't have accepted that a simple step such as that Mr. Cook says he would have taken, guarding the plate, would not have been taken before the accident. Well, my lady, I'll just ask. Yes, I made it before 4:15. So unless I can assist further, those are my submissions in reply.
Thank you all very much for your submissions. We'll reserve judgment. Two things about handing down the judgments, which counsel may well, but I still have to make them in every case. We send out a draft judgment to counsel. Draft in the sense that we invite corrections of typos and obvious factual errors like wrong dates and so on, but not for re-arguing the substance of the case. And secondly, that until the judgment is formally handed down digitally by being put on the National Archive and so forth, the contents of the judgment are confidential to the parties, that is to the appellant and his wife, and on the counsel's side to their legal department and anybody else from whom instructions have to be obtained, but the result of the case and the contents of the judgment are not to be disseminated further in the interval before the formal hand-down. I think that covers everything. Thank you all, not only leading counsel who did the speaking part, junior counsel for the appellant who did the speaking part, junior counsel for the respondent, and solicitors on both sides for their work and support. Thank you very much.
Report by Stable.